Good afternoon, everyone. Today's March 18th, 2026, and we're going to talk about spring cleaning your estate plan to refresh and organize your plan. As a reminder, Merhab Robinson and Clarkson focuses on estate planning and business planning for the employer and creating entities and making sure that your family is protected through the estate planning process. I'm Paula Clarkson. I'm the head of the estate planning department, and I'm going to be your presenter today. So let's get started on our cleaning. So over time, even the best created plans become outdated. Life happens and they need to be updated. So today we're going to talk about why they just naturally become outdated, what you can do and how often you should review your plans, common issues that we see during those reviews, and how life changes affect your established plans, and practical goals to keep your plan organized and working. Because our goal is always to prevent surprises for your family and make sure that your family is protected and that the transition after your passing is smooth and tax-free as possible. So let's first start with the ways that your estate plan can be outdated. The biggest thing is that the laws change. Over time, we have estate tax exemption changes. That's how much you can pass estate tax free when you die. It has gone up to 15 million this year. State law often changes as well, based on changes in the times and new information. Retirement plan laws have changed recently. Just in the last 10 years or so, we had the Secure Act and the Secure Act 2.0 that detail when you can make distributions, are you allowed to stretch it over your lifetime, and different things like that. And those become very important for your plan. Also, we always want to look at the healthcare in your power of attorney statutes. These are also important too if you were to happen to create an estate plan in one state and then move to another state. There might be slightly different rules governing the state laws and how things are impacted. So it's always important to take a look at what the current laws are and make sure that your plan it still fits that. If not, it may need to be updated. The other biggest area where plans become outdated is financial circumstances change. People will buy and sell a house, they change their residence, maybe their investments grow, they start a business, they sell a business. Maybe from the time they created their estate plan till now, a family member has died and they've inherited more money. So, was that money put in the trust? Was it just opened in an account in your name? Or was real estate just transferred to the beneficiary in their name? Any retirement income changes. If you retire now, do you have a lot? You're going through your money faster. Do you have any illness where that impacts potentially what you've detailed in your plan? We see a lot of people they might say specifically, I want this account to go to this beneficiary, but 10 years down the road, they may not have that account anymore, or the account may have a substantially different amount than they had intended to go to a beneficiary. So all those things are very important because the impact on it is how we distribute, tax strategies, and really, if your assets have changed, your plan may not follow because your plan was created based on a certain set of circumstances. The last main area where plans become outdated is your family situations change. People get married, they get divorced, they have more children, grandchildren. They have, blended families, having to deal with those things, as well as, changing in relationships. We see a lot of people that will come in and they will have, maybe friends named as guardians or family members for their children or as backup trustees. And for whatever reason, they don't have a relationship with that person anymore. So it's really important to take a look at who are the people involved in your plan who need to be included, and who are the people that you've named to take care of things. Um, it's really important that you have the right people in there. I've seen it a number of times where family and friends that are just not part of their life anymore are the decision makers. And it's always uncomfortable having to reach out to them and ask them to resign or different things like that. So the most important thing to remember is that your estate plan should grow with you. It is a revocable living trust. All of your ancillary documents, your will, your power of attorney, your healthcare document, they are all revocable and able to be changed while you are alive. So it's really important that you review your plan, title to the assets, beneficiary designations annually, because it will change based on your life. And I know sometimes we have clients that are very stressed about creating the perfect plan. And this is one of the benefits is we want to look at it at this point in your life, maybe looking forward the next 5 years or something. We're going to make the best decisions that we can based on the information that we have. But it's always a good idea to go back and review it because maybe something that you anticipated happening did not happen. So you want to look at it, make those adjustments as necessary, so that your plan continues to coincide with your wishes. One of the things that we offer for our clients is a review of your plan every 3 years. We figure that's generally enough time to have law changes, family changes, asset changes. But we do have some clients that prefer to review it annually, and we're happy to meet with you and go over those things as well. So some of the common issues that we find on review happen over and over again. So the biggest things are beneficiary designations don't match their plan. That there's an assumption that um, the trust controls everything, but it doesn't. Not everything is allowed to go in your trust, and we're going to go into that in a little bit. But things that like retirement plans are held outside the trust. So those are going to have beneficiary designations. Or sometimes we'll have clients that choose not to put, for example, a checking account into their trust. And what'll happen is they'll name a beneficiary or they will have a joint tenant, maybe putting their child on as a joint tenant on the account. Well, that designation trumps the trust. So what'll happen is that asset checking account or retirement account will pass according to the terms of that beneficiary designation. Um, Going back to the main situation where we have parents will put their child on an account to help them pay bills. And they think, oh, great, this helps them do that. We don't recommend that at all. If you have a trust, put the assets in the trust. If you need to have help, we can add your child as a co-trustee. But by putting your child on your account as a joint tenant, now that asset is technically theirs. I mean, they can walk in and they can drain the account at any time. Their personal creditor can get into it if they were to be sued or anything like that. And then upon your death, the surviving joint tenant owner is the one who gets that asset. And that may not necessarily be what you intended. I would say almost every time I've had this discussion with clients that they turn around and they say, well, I put them on there for convenience, but I don't necessarily want them to be the beneficiary. Now, there are circumstances where that is correct and that they do want them to receive that asset. So it's very important that you go through and we double check that. Um, with beneficiary designations, the biggest areas are like retirement plans and life insurance that, the beneficiaries are not updated. Sometimes we'll even still see ex-spouses on there. There'll be, we had one client that came in that had been married for over 20 years. They had had 3 or 4 children, and the beneficiaries on their estate plan, on their retirement plans and everything were their parents because those were all created before they had children. So effectively, they would have disinherited their children just because they had not updated their plan as those life changes took effect. Sometimes there'll be one child, like we mentioned, on a joint tenant versus multiple children. Or I hear a lot, oh, this child will just share it with the rest of them. They legally don't have to. But also, when you do that, you create problems for the child. Um, because if you leave it all to one child and ask them to designate it, now the child is the owner of those assets. And when they transfer those assets, maybe to other siblings or to grandchildren, they could be making taxable gifts that could have an impact on their estate plan. So it's always a good idea just making sure that we're putting the assets. If they need a beneficiary, the proper beneficiary is listed, not someone or something that we think is going to do it. Um, we also see people will put an asset in the trust. They'll, for example, retitle their checking account to the name of the trust, and then they'll go ahead and on the account, they'll put a beneficiary. So that becomes contradictory. So you're either going to put the asset in the trust, like retitle your checking account to the trust, so that when you pass away, that asset will flow and to be distributed according to the terms of the trust, or you can have the asset transfer via beneficiary. You have to pick one or the other. So it's always really important to make sure that you're doing the right one, and that beneficiary designations will override whatever the terms of the will and the trust are. So it's always important to double check all those different areas. We always want to, like I mentioned, look at the fiduciaries, because we often see, people are very nomadic now. We have trustees that retire, they relocate to a different part of the country. It might be difficult for them to continue being the guardian of your child if they move to the East Coast. Maybe the person that you've named is now older. Maybe they have their own health issues. Maybe they're taking care of a loved one, and maybe they just don't have the bandwidth to continue being the successor trustee for you. This is one of the reasons why we think it's really important that you name multiple successors. We usually like you to name two or three after, for a couple after the spouses, name two or three, because if you don't update it and maybe your first named trustee or agent on your healthcare is unable to do it, they can resign and you have backups in place. But it's always a good idea to take a look at those. One of the biggest areas I think when we change is when the children become adults. Oftentimes we'll do plans and the people will have minor children, and they're not in a great place, to do it. But once the children get in their 20s, maybe 30s, oftentimes they are now replacing other people and becoming the healthcare decision maker, becoming the successor trustee to help their parents be able to manage the estate. So there becomes a lot of conflict and issue when things are not up to date and correct based on the family situation. Um, Assets change over time, as we discussed. So it's really important to make sure that your estate plan and your assets coincide. So we see it a lot with people will create their trust, they'll put their assets in their trust, and then after that, maybe a year later, they'll change financial institutions, but they forget to put the new account in the name of the trust, or they will refinance their house. What happens a lot is, we'll help the client deed the house into the trust. And then upon a refinance, sometimes the lender will deed the house out of the trust. And they forget to think about it. They're just happy that the refinance is over. And what they don't realize is that the house is now in their names again and not in their trust. So it's always important to double check those things. And we see that happen a lot. When you have the new retirement accounts, when you're going from employer to employer, or you're taking your 401k on from an employer you left, rolling it over to an IRA, making sure that when you do that rollover, one, that you actually name a beneficiary. We go through probate a lot because people do not name beneficiaries on their retirement plan. And it's unfortunate because they can lose a lot of tax benefits by doing that. Over the last 10 or 15 years, people are accumulating more digital assets, cryptocurrency, and things like that. So it's important to make sure that those are titled appropriately in your trust and can pass the appropriate way, according to your plan. As well as, At this point in time, we're seeing a lot of people sell their businesses, retire. So we want to make sure that, if you retire, are you putting your new out, the proceeds from the sale, or setting up your plan so that your assets are in the trust and they pass the appropriate way? So let's go through generally how to make sure that your assets are appropriately in your trust. So the assets that should be in your trust, and when we say put them in your trust, retitle them to the trust, it is the person's name, for example, Jane Doe, trustee of the Doe Family Trust, dated January 1st, 2026. The date is very important because there may be multiple Doe family trusts, and we always want to include the name of the trustee so that the institution knows who has the power to manage that asset. So generally, when we have a trust, we want to put all of your real estate, whether it's your primary residence, whether it's a second home, a rental property, a commercial property, we want all of your real estate to be owned in the trust. If you happen to own your real estate, like a commercial property in an LLC, then your interest in the LLC, it's called a member interest, should be the trust. So that way, all of your real estate is held there. And when you die, it'll be governed by the terms of the trust. We want all your financial accounts, such as checking, savings, money market, CD, your personal investment accounts, everything outside of retirement plans to be retitled in the name of the trust. So that means your Bank of America account, your Chase checking account, your Charles Schwab investment, wherever you may hold it, we want it to be titled as, for example, Jane Doe, trustee of the Doe Family Trust. If there's a husband and wife, it would be, John Doe and Jane Doe, trustees of the Doe Family Trust. Personal property, things that don't have title, clothing, furniture, artwork, books, things like that. We want to put those in the trust. Because they don't have title, we generally do a assignment of personal property. And it's a good idea to, kind of keep track of that, not only for insurance purposes, but so that we know what is in the trust. Vehicles are an iffy thing. I generally recommend that people do not put their vehicles in their trust unless those assets are of higher net worth and they are value and they would be subject to probate. So the probate limit is 208,500. So most people have normal cars that are depreciating. If you have a 3-year-old car, it might only be worth $30,000 when you pass away. So between the depreciation and being below that probate threshold, oftentimes we just keep the vehicles in people's names. Those are often an asset that gets changed out a lot. If you tend to lease your vehicles, you don't even have to worry about it because the lease is basically just kind of like a debt. You don't own that interest, so your lease interest would not be held in the name of your trust. Business interest. If you have business interest, you own a corporation, an LLC, a partnership, we want to have your interest in the name of the trust. So you may own stock, directly in a business, you'd want to put it there. If it's something like, you own 20% of an LLC or you own part of a corporation, always have your interest titled in the name of the trust. 529 plans. Those are important because we want to make sure that we have the 529 plans have two parts. They have the beneficiary, which is usually the minor child that you're saving for. And then you have who is the account owner. So, oftentimes we'll see husband and wife. And they'll both be the owners, but it's easier to put it in the trust. And that way, if the parents were to pass away before the child is an adult, that the owner can change and there could still be continuous management of it. We've had to probate those on occasion because there was only the one person named as the owner. It was the one that passed away. Now, things that are never allowed to be owned in the trust, so this is held title in the trust, are going to be your retirement plans, your 401k, IRA, Roth IRA, 403b, pensions. Those are not held in the name of the trust. An individual retirement account is your name. The trust can be a beneficiary. We're going to talk about that in a second. but the legal owner of those is the name of the trust, or I mean, is you, sorry, individually. Same thing with HSA, medical savings accounts, Social Security benefits. So they're always going to come to you. You can make them payable to an account that is named in the trust, but they're always going to be payable just to you. And sometimes you may have contract restricted assets, such as you might have stock shares through your company that have not vested yet. Those would not be allowed into the trust. But as soon as they vest and they are yours, then you would want to make sure that your interest is held in the trust. So there's kind of a theme with these assets, and it's mainly they are tax driven assets where there's a certain benefit to you as the individual, which is why they're generally not allowed in the trust. But for these, you're going to name a beneficiary on them. The beneficiary can be the trust or the beneficiary can be an individual. It really depends on your situation. If you have a beneficiary that has some issues, addiction issues, they're minor, they're financially responsibility, creditor issues, naming the trust might be the appropriate situation, but there's going to be some trade-offs, and often those are going to be some tax disadvantages. So it's really important that based on your situation, that you consult with your attorney and tax advisor to determine, what is the best option. Like I said, naming the trust as the beneficiary or naming individuals specifically as the beneficiary. Now, there are assets that, like I said, naming the trust as the beneficiary or an individual. We're going to look at it. And when you do that, you say the Doe Family Trust dated January 1st, 2006. You don't have to put the trustee on that part because you're just naming the trust as the beneficiary. And like I said, that may be retirement plans. I always recommend that your life insurance be named the beneficiary is the trust. Because if you have a married couple and the insurance is on the spouse that dies and it's paid to the trust, generally the surviving spouse is the beneficiary of the trust. So it's all in there and it keeps it all under one umbrella. And also for children and things like that. It helps with that. Um, Sometimes there are needs or desires to name POD accounts. That means payable on death. They're often referred to as TOD, transfer on death. And that we do that a lot with there's an institution, a bank out there that if you already have an account there, you have your check, you have automatic deposits, you already have it set up to pay your bills and things like that. And if you were to go in and ask them to put it in your trust, they make you open a brand new account. So in order to get around that, sometimes we will recommend, hey, the easier way to do it is just to name a payable on death beneficiary for your account to the trust. And it's just a designation, generally for financial accounts. Oh, and then your HSA and medical savings accounts as well, making sure that you do have beneficiaries on those. Now, the beneficiary can be a trust or it can be an individual. So, what you want to look at again is, are your beneficiaries minors? If you have beneficiaries that are minors, you can't leave them a 401k, because then, if they inherit a $100,000 401k, then a guardianship needs to be opened for them and the court needs to be involved. The easier way is to name the trust as the beneficiary. You may have a beneficiary that's financially irresponsible. You may have beneficiaries that, if you have a substantial life insurance policy, if you have like $1 million life insurance policy, you may not want to give that to your beneficiary if they're in their early 20s. You may have set up your estate plan to say you get some at 25, some at 30, some at 35 by staggering the distributions. And that way it's a way for you to control that they're not getting that lump sum. Now, if you name the beneficiary directly, they would get that $1 million outright at whatever age they are. Sometimes the beneficiaries have some creditor issues, and naming the trust, even if you have to take an adverse tax position, is a better thing than potentially losing the asset to the creditor. I also like to add, especially like life insurance, is liquidity. Sometimes we'll have a family that has, a house that has substantial value, some minor liquid assets, and then a large life insurance policy. Now, if they were to name, let's say they have two children and they name them equally as beneficiaries of the life insurance policy, then equally on the trust, but one of the children wants the house and the other one wants cash, then they have to kind of buy each other out and things, and it could cause property tax changes, tax, other issues. Where if that life insurance had been put in the trust with the house, then when we divide the trust 50-50, we might be able to allocate the cash to one side and the house to the other and avoid some potential tax consequences. So it's really good for helping people. It's good when we have, a business in the family where one child is maybe in the business and wants to continue it and the other child doesn't. It's a great way to get liquidity in there. So is all you do is on your life insurance beneficiary forms, you name the trust. We always want to look at our healthcare agents as well. They're just as important as your financial decisions. Who makes your medical decisions and has that changed over time? Do the people that you've named continue to have your same decision, goals and things like that? Will they stand up for your decisions? Or even things like, I have a client recently that has a severe health issue. And based on knowing they have that specific issue, we went in and updated the healthcare directive to put some language in there regarding that and how they want treatment on a go forward basis because they know the treatment surrounding that and the consequences in the long run. So those are always important things to take a look at. So it's really important that you stay up to date on your estate plan. So what do we recommend that you do? We want you to review it periodically. I think right now, when you're doing your taxes, is the best time to do it. You're getting all your 1099s, you're double checking things, and it's a great time to see what is the title on those accounts. So, review your list of assets, check your beneficiaries, determine, is there been any major life issues like the marriages, divorce, new children, things like that. As I mentioned, looking at it individually, at least annually, doing a professional review. Take advantage of our 3-year reviews. We have clients that we don't hear from a long time. We don't charge you for the 3-year reviews. And oftentimes we can have the conversation in less than a half an hour. So it doesn't hurt to sit down and go, okay, what laws have changed? Looking at my situation, what assets have changed. And we're going to go through these things with you just to make sure that everything is good. And a lot of clients, it's like, great, everything is in order. We'll talk to you again in 3 years. But it's important to keep that up to date and make sure that we're reviewing that. It's also a good idea to keep a current asset inventory. So making a list, what are your assets? Confirming the title. Are these things with beneficiaries? Now, when we give you the estate planning binder, you have a Schedule A at the back of the trust, and that is saying what you intend to put in your trust. Okay. And as we mentioned, it's a great checklist for your successor trustees. It's a great checklist for you. And we really do want you to retitle those accounts into the trust. But things such as your retirement plans are not going to be listed on there because they're not held in the trust. But there is a place in your binder that's for insurance, for retirement plans. So those are great places to put all that information. And, we want you to put the support for it. So whenever, if you come in and you already have a trust and we're doing a review, we always pull up your deed. We want to put at least a copy of the deed in your estate plan so that okay, this is how title is held. If you do a refinance or something, double check it, get your original deed and make sure that title is correct so that there's no problems. When go to an, with your life insurance or retirement plans, print out a copy of your beneficiary designation, put it in your estate planning binder. That way, it makes it a lot easier for your successor trustee. And you can also do a very quick double check annually to say, oh, is this right or not? Okay. And oftentimes, when we're doing like, if you have an investment account or something like that, you don't need to keep putting, every monthly statement. We really just need to show when you put it in the trust, get the first statement that has confirming it's titled, because it's really just on the address label. We'll show you the confirmation. Just put page 1 in your estate planning binder. And that way it's very clear that it's not there. And it will help your successor trustees and your healthcare, your powers of attorney if you're incapacitated, and they need to take control of your assets. They want to know where they are. A big thing too is to get rid of the old documents. Um, I do think it's a nice thing on one hand to, maybe keep page one of an old statement. If you decided you were at one institution and you don't like them anymore, and you go to another, make a note. This account was closed and moved to new institution so that when you pass away, because if your successor trustee finds documents that one time you had an account at Wells Fargo, they're going to have to go down that rabbit hole and double check and make sure that there are not assets there anymore. And you could be wasting their time, or there could be other issues. So it's a good way to, if you have older documents, get rid of them, or at least put notes on them that those accounts are closed, where they've been transferred to, and so forth, so that there's a nice way that your successor trustees can find your assets. Also review your fiduciaries, like we said. We do your estate plan, one of the first tabs of your binder says nomination summary. And it's just a quick summary of who you've named as guardians for the children, trustees, your agents on your power of attorney, your healthcare decision makers. So you don't have to look up every single document. So that just takes, a couple minutes, double check it. Are these still the right people? Do they fit? If not, then give us a call and we can always make changes to that. So keeping your plan fresh. We don't want your estate plan to fail. And a lot of people think like, oh, well, everything's fine, but they may not realize. So for example, in the early, like in 2005, if someone had a $5 million estate, everything that they owned, they would be potentially subject to estate taxes. So trusts were drafted a certain way back then, often dividing when the first spouse died to take advantage of both spouses' estate tax exemption. But now with the estate tax exemption being at 15 million per person, and the advent of the portability election, meaning the spouses can share their estate tax exemption with each other, there isn't often that need to force the trust to be divided. So those are the law changes we want to look at, because your trust may have been perfect and drafted appropriately for your assets, for the laws at that time, but 10 or 15 years later, 20 years later, they may not be the same. So it's not that the trust was bad, it's just that the times have changed and we need to update it. And it becomes sometimes a problem if you've passed away and things have not been updated. So having to figure out what's going on and fix those. So as I mentioned, it's ever changing. Change it along with your family as you grow, as you shrink. And a lot of people, as they get older and retire, want to consolidate and simplify. So that's a great time. Double check everything, make sure that everything's in line. Another thing to do, since we are in the spring, we have a lot of graduates coming up soon. As your kids are turning 18, a big life change, and they're graduating from high school, potentially even from college, you as the parents can no longer make medical and financial decisions for them when they turn 18. If they were in a car accident, we had one of my partner's son was in a motorcycle accident and he was in the hospital. He was unconscious for a little bit, and the hospital would not talk to her or her husband because the child was over 18 and they didn't have any documentation at the time to talk to the doctor. So they had to just wait patiently until he woke up, because, and the doctor was appropriate that they don't know who those people are. They don't know if they're estranged. So having your kids, we want to create them, a power of attorney, healthcare directive, so that you can make the medical decisions. The HIPAA says who the financial or who the doctors can release medical information to. So it's really important to have that. I mean, technically your children don't have to name you. I think every single one that we've done, they've always named their parents, but they can name someone. But someone is better than no one, because if they were in that situation and they maintain their incapacity, then the court needs to get involved. When we look at the young adults, they don't necessarily need a will or a trust. It's just part of the plan based on their lifestyle. The rules in California are the probate threshold is 208,500. I have a 19-year-old. She does not have that much money. So, she has her checking account from her job and everything. But, if she were to pass away, I'm not too worried about it because it's under that threshold and legally it goes to her heirs at law, which are her parents. Now, she can go ahead and name a POD on the account if she wanted to name her brother or a charity or something like that. That's perfectly fine. If she has her first job and she has a small 401k or she has an IRA, she can also name beneficiaries on that and doesn't necessarily need a will or a trust. So we want to look at that. And then we go, and those are important too, because we'll do the plan for the children as they turn 18. But then, as they start working, they get their jobs, they start acquiring their own assets, then their estate plan is going to change as their life evolves. They get married, they have children. So it's always an ongoing thing to think about on the changes that affect your specific plan. So I know that was a lot of information. Keeping things update is very, very important. If you have any questions about your own specific plan, and you just want us to take a look at it and remind you what it says, go through your funding and who should be either your beneficiaries or what assets should be in the trust, we are more than happy to work with you on that, and go through that. It doesn't look like we have any questions at this point. So I'm going to go ahead and we're going to conclude for the day. But if you decide that you have any questions, please feel free to reach out to us. You can reach out to us at estateplan@mrclawcorp.com. And feel free to register for our next webinar next month on April 15th. We're going to go over trustee school, how to administer a trust after someone passes away, and all the steps that are necessary to take for your successor trustee. Basically, what does their job entitle? So thank you for attending today. We'll send out a replay of this as well as the slides. And oh, sorry, we have one question. It just says thank you. So thank you all. I hope you have a great day and enjoy the weather. I hope you stay cool.